So to everyone who was here last week but not the week before, hello. My name is Roch Ripley. Just very brief background. If you weren't here the first week, so I graduated from UVic Law in '06. Before that, I did an engineering degree. And right now, I practice at Gowling's, just finishing my 6th full year after call, exclusively in intellectual property and within IP, mainly patents, licensing, and related matters. So what I want to focus on today is giving you a survey of the intersection between IP law and video game law. Can you click? And hopefully from that you'll get 1 or 2 paper ideas. And of course, feel free to interrupt me or throw tomatoes or whatever else you might want to do during the course of the presentation. So here's intellectual property in a slide, because I want to spend most of the time focusing on video game law. Have people here taken IP? Can you just roughly? Okay, so very, very quickly, multiple rights, trademarks, copyright, industrial design, trade secret patents, they intersect in various ways. For our purposes, in this talk, I'm going to focus on 2 of those rights, one being copyright, the second being patents. Of course, video game law involves more than these. The only one that, while researching the book and working and talking with John, that I think we haven't come across a lot is industrial design or design patents. But even there, I could see how they would apply. I was thinking the other day, what's that PlayStation, the PlayStation version of the Kinect, the wand, the Move, whatever it is? That's kind of unique and funny looking, so long as that design is not dictated solely by function. Potentially, Sony could apply and get design protection for that. But in terms of the case law, you don't get too much of it. The other comment I have to make here before we move on is within trademarks, you get a lot of cases involving endorsements or personality rights by famous people. For example, there are several cases involving those dance games where you have rockers or singers who say that their likeness has been taken and incorporated into the game without their permission. And you can think of that as a kind of trademark right, in that the rocker is saying, look, you're making it sound as though I've endorsed your game. Some of my reputation is passing off, really. But again, today, copyright and patent just because of time. So this, you heard John talk about last week. I thought I would start at the same place where copyright was acknowledged in that game. It's amazing how far we've come. A couple things there. So the issue there was whether or not you would have copyright in the end audiovisual work. The answer was ultimately yes. If you're in practice and you're thinking, someone's appropriated this, how do I, on behalf of a client, analyze the case or stop or defend? Think about all the rights that are inherent in this game. So yes, copyright in the audiovisual work. You've got copyright in the underlying source code as well. If we're packaged, you'd have ancillary rights related to the packaging, the marks on the box, everything related to distributing. So usually if there's been an appropriation of some kind or a misappropriation, it's not just the screen per se. Usually you get a little bit more. Go to the next one. So variations on a theme. Is there copyright in a game? Sure. The other thing I should mention with that actually is that the issue still comes up sometimes. A couple of years ago, there was an action between Atari and Research in Motion about Breakout. Blackberries used to be shipped with Breakout. You know that game where you bounce around and the ball comes and you hit the bricks and you break them? Atari had alleged that RIMS including that game was a violation of their copyright. RIM sued to get a declaratory judgment of non-infringement, and one of their pleadings was that there was no copyright in the game. I don't think that actually made it to court, at least not that issue, but you still see it pled. No, one back. The other back.
Uh-oh.
Here.
Yeah. Let's do it that way.
Or click that. I thought technology is supposed to make our lives easier.
Yeah, sorry.
There we go. There we go.
There we go.
There we go. So variations on the theme. One case, Dream Games versus PCOnSite, had to do with bingo. I don't think that picture is actually one of the games. I tried really hard to find it, but my internet skills were defeated. So this is just some kind of random video bingo game. The context of the case is Dream Games had retained PCOnSite to work on a new version of the bingo game. As so often happens, the relationship fell apart. PCOnSite then took the game, or a very close variant thereof, and started commercializing it, and Dream Games sued. A couple interesting points from this case. Reinforced copyright in a compilation, so even if you have underlying elements that are not protected by copyright, if you arrange or compile them in a certain way, that compilation can be protected. So I mean, to take this as an example, I don't know if you would get copyright in help buttons, balance, the balls, the boards, or whatnot, but arranging them in this 2x2 array with 4 rows of balls and whatnot, you can make a case that the compilation, the whole, does have protection. The other interesting thing about this case was, as close to gambling as I think I'll get, is this was used for gambling illegally in some places. And the argument was made by PCOnSite, listen, we use it illegally, so you can't get any damages because you should be presumed to have used it legally, which means you would not have used it how we used it. That didn't work. The court said, no, illegality is not a bar to statutory or legal damages. And Dream Games, this is a circuit decision, so that came down on appeal. The district court, Dream Games, got an injunction against PCOnSite, which when I read it actually surprised me a bit because an injunction is an equitable remedy. And there, if you, what's your irreparable harm if you cannot practice that game in the jurisdiction where the defendant is practicing it? Anyway, it must be there somewhere because they got the injunction. So we've got from copyright in a game, copyright in a compilation, damages aren't barred by illegality, which is one step further. Next slide. We also talk about things you can do to games. So going back to the early 90s, which when I was putting this together gave me many flashbacks, must have been my gaming heyday. Talk about reverse engineering. And just like on, I think still with DVDs, but with games, they had games that were encoded so that you had to get a license, for example, from Nintendo to be able to play a game on your NES. You couldn't just go make a game and then sell it. And Atari didn't like this. So what they did was they went and got some code from Nintendo that they used code from Nintendo that Nintendo used to prevent third parties from playing unauthorized games on the NES, the Nintendo Entertainment System, reverse engineered it, figured out how that digital lock worked, and then put out their own games. The wrinkle there is that to get a copy of the code, Atari filed a request with the US Copyright Office saying there is litigation that is currently ongoing. Please give us a copy. There's an exception in the act that says you're allowed to give us a copy, but there was no litigation that was ongoing. So as a general rule, the case says basically reverse engineering is okay. Don't go beyond what you need to do to understand how the program you're trying to reverse engineer is engineered. But if you limit yourself, it's okay. But by the way, you essentially stole the code. So we're not going we're not going to allow you to take the benefit of a fair use defense because what you did was not fair, it wasn't equitable. On a related note, it's surprising that Atari's lawyers even did it. If a client asks you to do something unethical, you just have to say no to them. But as has unfortunately been shown many times, if you're pressed economically, certainly, especially if you're an in-house lawyer and have one client that your mortgage is riding on, maybe you just make the wrong decision at the time. Anyway, don't do it. The next case, Sega versus Accolade. Now you can scroll back one. Sega versus Accolade. Same general idea, except here there was no getting code through illegitimate means. So Accolade, which was trying to reverse engineer the protection or encryption or digital lock that Sega used on its Sega Master System, they were found to be allowed to do that. The wrinkle was that the digital lock was intertwined with the Sega logo. So I don't know if anyone ever owned one of these. I owned it. You power it up, the first thing you see is that logo. It also makes a sound, which today you could probably argue is a sound mark to get protection for, but that's not an issue in the case. The logo comes up, and you have to display the logo if you're going to get into the game. So Accolade also had to display the logo. So the issue of trademark infringement came up. And that's a little thornier, but the court essentially said, listen, there's no way they can exercise their fair use rights without having to display that trademark. It wasn't Accolade's objective to commit any kind of trademark infringement or passing off, which is a bit of an odd thing to say because usually objective doesn't matter too much. And Accolade also included a disclaimer, which helps your case, of course, in a trademark action because you're saying, even if you initially thought I was the source, I'm telling you I'm not the source. So they were found not to have committed any kind of trademark violation.
Sega, Roch, couldn't Sega simply have had a contractual term in an end user license agreement that said you can't reverse engineer?
We're getting there. So this was the real flashback, but anyway. Then you get to enhancing the game. So we've talked about reverse engineering the game, enhancing games, the Game Genie. I don't know how many of you know about the Game Genie. Basically, you could attach it to your game, plug it into your system, and then, cheat. Nintendo tried to prohibit this, and they said, listen, you're violating the copyright we have in the game. And the court said, no, they're not. The Game Genie is an enhancement. It does not, in fact, create an independent derivative work. So without creating that work, there is no copy. So Genie away. So next, another issue that comes up in the copyright realm is content originality. What was your inspiration for the game? Where did you get your idea? Not only in how the game plays, but how packaging looks, the ideas, the concepts. So one game here, or not one game here, actually it's two games, one case. Incredible Technologies and Virtual Technologies. And I don't know if they're still in bars because now I'm married with a daughter. But when I was younger, I know they were in bars. You had the Golden Tee game. Next slide. Right, which is this thing on the left. You've got the roller ball, the buttons. I don't know what the buttons does or what the buttons do. I barely remember what the ball does. I don't think I've ever played this game sober, to be honest. But anyway, you play this game. Somehow golf is played with the ball. Something. This was the allegedly infringing game. And it's probably tough to see with the resolution, but there is a ball here. There are buttons here. Of course, there's golf being played and golf images being displayed. And maybe a general similarity in the cabinet. That was an issue in the case. I don't know if I found the right cabinet. There are a lot of these different machines that were made, but in any event, the makers of Golden Tee tried to stop the makers of PGA Championship Golf, whatever it was called, from making this game. And they were unsuccessful for a variety of reasons. One of the arguments was that there's copyright in things like the curved side panel of the case, relative position of the buttons and the ball, things like that. And the court said there, listen, that is very utilitarian. If there is any copyright protection in that, it is so minimal that there would almost have to be an exact copy of what you've done, and they didn't see that. So there was no infringement there. Another argument was that the game itself copied elements from the Golden Tee game. So for example, you would play golf, and then like you see on the PGA, you've got this little mini map in the corner that shows where the hole is, that shows where you are, that shows your yardage, et cetera, et cetera. And that was present in both games. And Golden Tee argued, so that's copying. And the court said, no, that seems unfair. That's a stock element in a kind of game like this. So you can't hang your hat on that either. They could have, if there was copying of these logos, which clearly are very distinctive and are protected by both copyright and trademark, could have won on that, but Electronic Arts, being very well represented and having been advised prior to making this game, I'm sure, did not copy that. And therefore, that wasn't an issue. But here you see a court using various techniques at its disposal to find that there was no copyright infringement. Stock elements, even if there is copyright at very low level, which raises the threshold required for infringement, and no copyright in something that is purely utilitarian. This case I've thrown in just because I think zombies are kind of neat, but it does go with the flow, so to speak. On the right, you have a very famous movie by George C. Romero, Dawn of the Dead. On the left, you have a game called Dead Rising made by Capcom, where I guess you are this guy with a shovel, and you have to kill all these zombies. Looks like a very difficult game. So what happened was the person who owned the rights to Romero's movie sued Capcom, saying, you've copied our game. They also, if you're interested, alleged various trademark infringements, which I won't get into, but it's not too hard to find the case in the book or online if you want to read that part of it. Next case. And here are the various ways in which Romero tried to make its case. I mean, I won't read them all for you. Yeah. So I think when you read all of these, you kind of come to the conclusion the case is not particularly strong. Which also raises the issue, if you're representing a client, you have to know when to give them bad news and when to say, regardless of how hard you want to pursue this, you are almost certainly going to lose. A couple interesting things. The court basically went through each of these element by element and dismissed them using a variety of techniques. Well, I'll give you a couple examples. So one of the points here, where is it? Here it is. Both works were a parody of rampant consumerism. So there was the argument that the works share a common theme, and the court said, to the extent that Dead Rising the game may be deemed to possess a theme, it is confined to the killing of zombies in the process of attempting to unlock the cause of the zombie infestation. So I think you get the sense that it wasn't really that close either. And the court summed up all these points by saying, look, this is nothing more than a string of disconnected facts and generic ideas which are not protected under copyright law. So here another tool the court has to say what you've played does not even rise to the level of a work. And you get protection for works.
So the zombie infestation is not when articled students arrive at big law firms?
No, they
Okay.
still have life when they arrive. It's not till you practice for about 6 years that the life leaves. Just, we'll have to edit that. Yeah, okay. So John asked earlier, what happens if you get people to sign contracts in addition to exercising their copyright rights? Copyright rights? Copyrights. So everything before this slide, we've just been dealing with copyright per se. And here we're entering a series of cases where it was copyright and contract in the form of an end user agreement or terms of use, and the DMCA, the Digital Millennium Copyright Act, which provides protection for anti-circumvention, access control, and copy control forms of digital locks. An access control digital lock is one that prevents you from gaining access to a work. Copy control digital lock is one that prevents you from copying the work. First case, we'll talk about Davidson and Internet Gateway. Have you talked about this already?
No,
Okay. So,
next week, but yes.
okay.
You
Well,
go right ahead.
all right. So there's a service out there that Blizzard offers, battle.net, where basically if you wanted to play a game like Warcraft online, you would play exclusively through battle.net. And being a gamer when this was actually rolled out, it was genius, I think, on the part of Blizzard, because up until then, piracy, I don't know what the stats were, but certainly among my friends and not me, it was rampant. You could just take the CD, plop it in your drive, install it, and there was no way to prevent that from prevent you from playing the game. Here now, suddenly with Battle.net, if you require everyone who wants to play online, who has an installed copy of the game, to come together at a single point and provide identifying information like a CD key, you can stop all those copies from being played. So they've set up a system where your incentive is to comply. So they probably were not particularly pleased when some gamers reverse engineered the code that was responsible for Battle.net and set up their own independent gaming server. So there was a suit started to get an injunction and damages against these people who started the competing server. A couple of relevant facts. These people had agreed to both a EULA in terms of use that prohibited reverse engineering. And also the DMCA, of course, was in force. And the game required you to play to put in a CD key if you were using Battle.net. But if you were using this competing service, you would not have to input the key. So the people who set up the competing service, the defendants, lost for two basic reasons. One, the court held parties are free to contractually waive their fair use rights. And two, the CD key was a digital lock, and bypassing it violated the DMCA. So a second case that is probably near and dear to John's heart because it involves racing. It's iRacing and Robinson. And here there was a NASCAR racing game. A person modified the NASCAR racing game so that the cars included open wheels, and then they publicly made the executable available. The racing game, as shipped by the distributor or the publisher, had a SECU-ROM, anti-circumvention device, which means you cannot play without the CD you purchased in your drive. Again, of course, made to stop copying. To get around this, the person who published the open wheels version made a patch called No CD, which you can probably guess what it does. Again, the person had agreed to a EULA saying they will not reverse engineer, and the DMCA was in place. Interestingly here, the court said, I will find infringement, but as a point of law, a EULA does not prevent someone from relying on the fair use defense. If someone doesn't comply with the EULA they've agreed to, there can be a breach of contract, but not necessarily a breach of copyright. And again, a DMCA violation because the anti-circumvention device was bypassed.
Can I just stop you
Yeah,
there?
yeah.
What's really critical for you to focus on is damages. If there is only a breach of contract,
Yeah.
and you've created a mod to a game, it's going to be very hard to demonstrate that the existence of that mod diminished the sale of the game legitimately. So, because usually to play the mod, you would need the game. And I was part of this community. To play the mod that was at issue here, you needed to have the NASCAR game. Otherwise, there was no real mod that was going to function. And even if somebody managed to download a no CD copy, the number of people who would have done that in the community would be pretty tiny, and the damages would be pretty tiny. So it's fairly consequential if you just flip into there's no breach of copyright because it's a fair use. There's only potentially a breach of contract because the damages become more clearly an issue.
Yeah. So if we go to the next slide, we'll touch on that here as well. The third case I want to talk about that deals with copyright contract, the DMCA's MDY and Blizzard. This deals with World of Warcraft and people using bots to play the game for them while they're sleeping or at work or whenever to get super powerful characters and then to rampage through the game. So you have the typical EULA terms prohibiting reverse engineering, et cetera, et cetera. And here the court found, interestingly, the district court found one way and the Ninth Circuit overruled. They found a breach of contract but not copyright infringement because the bot does not in any way facilitate playing the game without having purchased the game. The bot facilitates playing the game in a certain way after you've purchased it. So they found no copyright infringement, which, as John just said, is important because of the difference in remedies and the different heads of liability that arise. So copyright being an intellectual property right, you're more entitled to proprietary remedies, specific performance, injunctions. With contract, generally damages is the rule. I mean, you can apply for specific performance as well, but you're not entitled to it as of right like you are with a proprietary infringement.
A lot harder to get an injunction in a pure contract case.
Also statutory damages, those are in copyright legislation. Contributory or vicarious infringement is in copyright. I mean, there's also the tort of inducing breach of contract, but proving those two things is different, et cetera, et cetera. So all liabilities were not created equally. There are real differences in terms of what you can get based on what you plead and how you win or lose. Because there was no copyright infringement, the court found there was no copy control breach, but the court still found there was a DMCA access control breach because to play the game with a bot, you had to modify the game, or the bot had to do something that circumvented protection called Warden that came shipped with World of Warcraft. So those are the copyright cases I wanted to talk about. So we went from the beginning where you found copyright or where a court found there to be copyright in a game. We talked about moving from copyright in the game to copyright in a compilation. Dealing with pure copyright, we saw how there were rights to reverse engineer and to enhance. Talked about the different tools a court can apply when dealing with pure copyright to balance the right to be inspired versus the right to have your work protected. And then we moved into contract and legislation, the DMCA, to see how that's altered the landscape. Now we come to patents. So basically, we've got software and hardware patents in the gaming realm. The distinction often is artificial. And we can talk about that a few slides down. A patent for, sorry?
Just a quick question. Of course, we've just had our Copyright Modernization Act,
Yeah.
which has brought in a number of provisions which are very similar to DMCA.
That's right. So now we have
So
also
the
copy
situation-
control and access control.
Yeah, that would be something we anticipate now, right?
Yeah, absolutely. Copyright, or excuse me, not copyright, patents for a game per se. So if you want to just, for example, attempt to get a patent for the rules of the game, which are where the innovation lies, and not for underlying hardware that facilitates the game being played in some way, I think there you've really got a problem with jurisdiction. In Europe, to get a patent, you need to satisfy what's called the technical effect test. So you have to show your invention solve some kind of technical problem. I think that would be tough to do if your invention were a game. The requirement, they don't have that requirement in the US. So it is possible in the US. And in Canada, we're sort of in limbo right now. There have been a couple of recent court decisions in the office. The patent office is analyzing those and still hasn't put out a practice notice. I think as a matter of law, the answer should be yes. The position is, for all intents and purposes, when it comes to games, the same as in the United States, but the office may yet disagree. And we have the relatively recent phenomenon of patent trolls, which I'll talk about now. So generally a troll is an entity that doesn't carry on business in the traditional sense, but owns a lot of patent assets and enforces them against companies. And I mean, that throws things for a loop for a couple of reasons. One, when you have two practicing entities, two companies that conduct business in the conventional sense, often there is real incentive to settle because you'll have both companies having a patent portfolio and nobody wants to sue each other and pay the lawyers and suffer the executive and employee downtime it takes to run a suit properly and to inject uncertainty in their business, which is ancillary to litigation. But with a troll or non-practicing entity, there is no business that's ancillary to litigation. There is no threat of a patent lawsuit in return because what of your actions are they going to sue? They can't sue you for enforcing a patent. I mean, they can sue you for invalidity, but that's what I'm talking about. So the dynamics change. You can't handle a patent troll suit the way you handle a conventional piece of patent litigation. Why has this happened? I mean, I think a few reasons. One, the law changed 10 or 15 years ago, probably 15 years ago now, 98. And the case people usually cite when talking about business methods, which are very closely related, usually to software patents, is State Street, which was a 1998 decision in the US, which basically said, yes, these kinds of patents are not as a class prohibited. There was the dot-com economic boom and bust. So you had a lot of companies, a lot of software companies, who while they were practicing and in business, investing in drafting patents, and then they go out of business and their assets are put into receivership and sold. And who buys them? And then you have litigators who see an opportunity and begin working on contingency for non-practicing entities. You want to?
You got 5.
Oh, I got 5. Okay. Talking about the dot-com boom and bust, This is for business method patents. I'm not exactly sure how they define that, but the trend is generally the same for patents overall. You see a big peak in applications filed near the dot-com boom. The allowance rate is relatively high as well. There's even a bump in the number of patents issued. Then you have the bust, and quite frankly, you have some judicial and administrative reaction to the problem of patent trolls, and you see things like allowance rate decrease subsequently. But you can't turn back the clock and take away all those allowances, and those are all still valid for about another 10 years. So there's a couple examples in the gaming realm. I mean, if you Google trolls in gaming, like John said, you're going to find cases. One is Game Tech and Facebook, Zynga, etc. I mean, I spend most of my day looking at patents, so when I hear a one-line summary of a patent, which is like this one, the patent would seem to cover the common practice of using virtual currency to obtain items in a game, and then everybody gets all angry because, oh my gosh, how can you patent that? It's so simple and easy to understand. How do they get a patent for it? Well, in fact, I went to the patent and I pulled it up, and this is what they have a patent for. So I'm not going to read this because I want to stay awake, but you can look at it for a second. I mean, to be found liable for infringement, someone has to perform each and every element or an equivalent. And that's a fair number of elements. It's certainly more than the one-liner.
And obviously, Roch slides will be on the blog this afternoon.
Yeah. Another case to show that not all claims are incredibly long and difficult to read. Here, Unilock, which is clearly a troll because they've sued in the Eastern District of Texas, which whenever you see that means troll, troll, troll. One-line summary, which I read online, an online authentication system that enables users to verify and access their data on a portable licensing medium. And what they actually got a patent for, next slide, is this. Which, I mean, if you sit down and read it and think about how these terms apply to real life, it's actually fairly broad. So you kind of run the gambit. So to conclude, I mean, some parting thoughts. You know, what's the current state of the industry from the perspective of IP law or contractual law? I mean, is there too much protection? Is the problem too much deference to contract, which might imply, in fact, not enough IP? Do you want to consider the DMCA a true piece of IP legislation? Things to think about. Was there ever a legal sweet spot? Before we got to EULAs and the DMCA, you saw the court balance various competing interests. Was that a good place? Or were courts getting out of date? Did technological change require things like the DMCA to come and to protect new business models? What should be changed now and how? They just passed a piece of patent reform legislation in the US after I don't know how many years of trying. It was always introduced every year and always died, but it passed the last time it was introduced. And in that piece of legislation, there was nothing done. Well, there were some things done, but fundamentally, I would say not much was done to address patent trolls. Should more have been done? What are the pros? What are the cons? And there are pros. And I think also, when you look at the cases, you see courts reacting to the times, so you don't have to wait always for a legislature to come and pass something new. So for example, I mean, in Canada, John's talked about user rights. So you have CCH, which was several years ago now. You've got the Pentology that just came down, one of which dealt with a video game law issue. So you see courts, I think, there reacting to the times. In the US, courts have also reacted to the issue of trolls. Decisions have come down relatively recently that makes it harder to get a final injunction. Makes it easier to invalidate a patent. All of this done without congressional approval. And of course, sometimes legislatures do get involved. We just talked about Bill C-32, the Copyright Modernization Act, which has passed and which has in fact expanded the scope of fair dealing to include things like satire and parody, as opposed to just research and private study, but at the same time has introduced protection for digital locks. And if I recall correctly, I think the penalty goes up to $25,000 and 2 years less a day. So certainly it is not insignificant. So you have all these various ways that different players in the legal industry are adapting. And are they doing a good job or bad?
Roch, I got one question.
Yeah.
Okay, so the class today has inspired me to come up with a new genre of game.
Okay.
And there is no such game. You can take it from me because I believe there's no such game because I've been around the gaming world in this genre for a while. There are no zombie race games.
Okay. I can see why, but
No zombie driving games.
okay.
So I want to come up with this genre. It's completely original. There is no precedent for it. Let's assume there's no precedent for it. I really believe there isn't. I come to you. What's your advice? How do I protect my game? And can I protect my genre?
Well, I think you'd have two issues. One, you'd want to make sure that you could make the game without infringing anyone else's rights. And two, you'd want to protect the game. So in terms of making the game without infringing someone else's rights, you would look at some of the things we just talked about. Where was your inspiration? Are you taking zombies or race? Are you taking the NASCAR executable, copying it, and just overlaying zombies there, which could be an issue? Or have you entirely created independently your own code and your own games? You can talk about things like stock elements. How original is a zombie and who owns that concept? I mean, nobody really owns the concept of a zombie. Zombies are zombies. In terms of protecting it, copyright arises automatically in original works you create. You probably have employees. You want them signed to employment agreements. You want them also to execute assignments after the fact. You probably want to register the copyright when it's done so you get a presumption of ownership should you have to enforce. You want to brand it properly. You want to do a clearance search on the trademark before you apply to register the brand, because if you have to rebrand, it can be very expensive, costly, or time consuming. You may want to patent it depending on how you've implemented the game. It's very difficult, I think. I can't think of an existing way to have a zombie drive a car. Maybe you thought of a new and inventive way to have a zombie drive a car. So you could do that as well.
So to try and tie the two talks together, every single thing that Roch said can also be seen on the flip side of the coin as a restriction on somebody else's creativity.
Well, that's exactly what it is.
And on that, we agree.
Yeah.
And we will see you next week. Thank you.